laws by not doing enough to analyze the impact the Growler expansion will have on human health, the environment, and historical resources, and also failing to consider ways to minimize those significant impacts. Our lawsuit seeks to force the U.S. Navy to comply with the law and thoroughly analyze the dangers the increase in loud growler traffic may pose to Washingtonians and our wildlife. Today, I'm also sending a letter to the Navy and the U.S. Fish and Wildlife Service advising them that unless they make changes, I will be adding more claims to the lawsuit in the future to protect threatened wildlife in our state. So let me do some quick introductions, and then we'll get started. So to my right is Bill Sherman. He's an attorney in my office, so he's an assistant attorney general. He leads the part of our office that handles environmental litigation. So he's Counsel for Environmental Protection Unit Chief is his title, Counsel for Environmental Protection Unit Chief. And he's been leading our efforts here in the AG's office on our litigation. To my left is Attorney Paula Spina. She's the spokesperson for Citizens of Eby's Reserve. That's a nonprofit on Whidbey Island that is filing a separate lawsuit on this issue. Also joined today, Bill Wilbur, who's the group's president, Marion Atwood and Michael Monson, who are directors. Jane Monson and Nancy Nordoff are members. Attorneys David Bricklin and Zachary Griefin. Also joining us are Donna Oswald of the Olympic National Park Associates. It's great to have Donna here because a little over 60 years ago, she was part of a protest hike along the Olympic coast in which she joined then Supreme Court Justice William O. Douglas. You may have read about this hike on the Olympic coast to protest threats to our Olympic coastline 60 years ago, and Donna was actually a part of that historic hike 60 years ago, so I've had the chance to get to know her since we did a similar hike this last year, so it's great to have Donna here. And also Rob Smith of the National Parks Conservation Association. Rob joined me and a crew on the 60-year anniversary of that hike. We were protesting potential oil development off Washington's coast that the Trump administration was considering. So Rob joined us on that hike, and he's aware of the concerns from park goers about the impacts of the growler jets on the Olympic National Park. So thanks to everybody who's joined us today. So before walking you through our legal claims, I'm just going to give you a little bit of background about growlers and the concerns around the Navy's expansion. Then we'll briefly describe how we believe the Navy has violated the law. We'll lay out what we plan to accomplish with our legal claims. Then you'll hear from Paula, who represents the Citizens of Eby's Reserve, about their lawsuit. So again, two different lawsuits, and Don and I will speak to those, and then we'll open up to your questions. So growlers are aircraft that fly low in order to jam enemy communications. The Growler program takes place at two airfields at the Naval Air Station on Whidbey Island. Whidbey Island is home to many important wildlife habitat areas, including those for bald eagles, tufted puffins, harbor seals, and a threatened seabird called the marbled murrelet. Eby's Landing, as many of you probably know, is the nation's first national historical reserve, is adjacent to one of the naval station's airfields and less than 10 miles from the other airfield. Several communities, of course, schools, and state parks are also nearby. As many of the individuals standing behind me are aware, these aircraft are extremely loud. A private contractor for Citizens for Eby's Reserve recorded sound levels above 100 decibels during growler flyovers. The Navy itself has reported sound levels under the flight path of growlers as ranging up to as high as 116 decibels. To give you a sense of perspective, a jackhammer is about 100 decibels. The noise a chainsaw makes is about 110 decibels. The Navy plans to gradually add 36 Growler aircraft to its fleet at the Naval Air Station on Whidbey Island by 2022, which would make a total of 118 Growlers. We do not know how many are there right now, but this is an expansion that is going on. The program expansion will result in nearly 100,000 annual takeoffs and landings. A couple of years ago, while the Navy was going through the decision-making process about the expansion, our Washington State Department of Health provided comments to the Navy about the potential human health impacts of increased growler operations. The state put the Navy on notice of these potential issues. Those comments warned that exposure to noise levels similar to those at the Naval Air Station may pose a threat to public health. The Department of Health identified many studies showing that exposure to this kind of noise may cause sleep disturbance, cognitive impairment, and cardiovascular disease. The Department of Health also pointed to studies that provided evidence that noise exposure can impair children's cognitive skills, and particularly reading skills. The law requires the Navy to study and fully consider the impacts of significant decisions that will impact Washingtonians and our environment before finalizing those decisions. The law requires that process. In other words, the Navy needs to look before it leaps. They did not do that here. Specifically, the Navy violated the National Environmental Policy Act. We'll refer to that probably as NEPA throughout this conversation, and the Administrative Procedure Act, often called the APA, a tool we've used repeatedly in our successful litigation against the federal government, by failing to sufficiently analyze the impact of the Growler expansion would have on human health, the environment, and historical resources. The following are two examples of the ways the Navy failed in its legal duty to study the impacts of the Growler expansion. First, the Navy ignored comments from the State Department of Health and failed to complete a thorough analysis of the negative impacts to health for both adults and children, including sleep disturbance and cognitive impairments. Second, the Navy failed to conduct a sufficient analysis of the impacts the expansion would have on certain wildlife in the area, including bald eagles and threatened and endangered seabirds. The Navy's analysis on the impacts to wildlife is insufficient in the following ways. First, the Navy assumes that birds and wildlife will just get used to the noise, just get accustomed to that noise, based on the fact that some birds and wildlife still live in the area with the current noise level. That's not good science. The amount and duration of noise matters to birds, and the Navy needs to look into that. The Navy also assumes the noise will have the same impact year-round, but of course, birds have different breeding seasons and migrating seasons. The Navy's report might have found ways to minimize the harm to birds if it had actually looked into the differences between species and between seasons. The National Environmental Policy Act and the APA, the Administrative Procedure Act, also require federal agencies to show that they have taken reasonable measures to mitigate any negative effects caused by their actions. They need to take that into consideration. What could they do to mitigate the harm that this is going to create? In its review of the Growler expansion, the Navy failed to do that. It failed to consider reasonable ways to reduce the harmful impacts and effects the plan would have on human health, wildlife, or historic areas. In addition to the violations I've mentioned before, our lawsuit asserts the Navy violated the National Historic Preservation Act. Congress established the Eby's Landing National Historic Reserve next to the Air Station Reserve to protect the rural community and significant resources. Extremely loud aircraft passing overhead spoils a serene, wild, and rural reserve. The Navy again failed to consider reasonable ways to protect the historic areas. The bottom line, with respect to the significant expansion of the Growler jet program, the Navy leaped before it looked closely at Growler's impacts on wildlife and human health. In leaping before looking, the Navy violated the law. Our lawsuit asked the court to declare the Navy's environmental impact statement as insufficient and therefore invalid, thus requiring the Navy to go back and start over. In other words, they need to go back and do it right. There is a reason the law requires the government to look before it leaps. Washingtonians deserve an accurate assessment of the impacts of the Growler jet expansion on human health and wildlife, and a thorough review of strategies to reduce the harms, and that's exactly what the law demands. We are also initiating a process to file an additional claim under the Endangered Species Act. That process starts today with the letter that we are sending to the federal government to give them 60 days notice. I won't go into the legal details of that, but before we can file that claim, we have to give the federal government 60 days notice that we might file it. That letter is going out today, and it's linked to our press release as well. Just to wrap up my thoughts, I'll say that, obviously I take suing the federal government seriously. This is our 41st lawsuit against the federal government. As many of you know, we've not lost a case yet. We've won 21 cases, we've lost none. I think it's also fair to say that if you're filing a lawsuit against a military branch of the federal government, you take that especially seriously. I'm from a military family. All my many uncles served in the armed forces. My father was a Navy man. He was proud of his Navy service, I can assure you. But as we were chatting before we came in here, my late father, was also a believer in following the rules. He believed in that. And look, despite being a Navy man, I'm confident he would think this is the right thing. The Navy's got to follow the law just like everybody else. They're no different. So they have an obligation to perform their vital and important national security function. No two ways around that. But they have an equal duty to the law and to Washingtonians and to our environment that we take very seriously. They have an equal obligation to follow the law when fulfilling their important mission. And the importance of their role in our society does not relieve them of their legal obligations. And that's what our job is, to make sure they're following the law, taking the right steps, so there's a transparent process that considers all the impacts to human health, all the impacts to our wildlife, all the impacts to EB's reserve and looks at potential ways to mitigate that. The bottom line is they simply haven't done that, and that's not okay. So with that, Paula is going to speak about a related but separate lawsuit. I just want to emphasize these are two different lawsuits, but obviously quite related, and she'll speak about those, and then we'll take your questions. Thank you, Paula.
Thank you, Attorney General Ferguson. Before I get started, I would really like to take a moment and thank the Attorney General, and in particular, two of his staff, Assistant Attorney General Bill Sherman and Aurora Yankee, I hope I pronounced that correctly, who have been working with us and who have put this lawsuit together. They took a hard look at the Navy EIS and the record of decision. They took a hard look at the Navy actions on Whidbey, and they're the first of our political representatives to really stand up for us in a big way. We have other representatives, our senators and our representatives have helped, but this is a huge step, and we really want to thank them. For many years, we've been fighting this battle. CORE was founded in 2012 in response to the Navy bringing the Growler to Whidbey Island. In 2005, the Navy issued an EA, an environmental assessment. It's a way around doing an actual EIS. And in 2005, the Navy wanted to bring the Growler to Whidbey Island, and it represented to the people of Whidbey and Washington State that there would be less impacts from bringing the Growler to Whidbey Island than there were from the current generation of aircraft they flew there, the Prowler. They told us they would only fly 6,120 operations per year at the OLF. That's 2 operations per touch and go, so about 3,000 operations. They told us for most operations the Growler was less loud than the Prowler. None of those things were true. We didn't know they weren't true until after the statute of limitations expired, when they started flying, basically in 2011 and 2012. In 2012, the citizens of Central Whidbey rose up to say, this is not what you told us, this is not what you promised, and that's when CORE was founded to represent the citizens of Central Whidbey. This fight has grown well beyond Central Whidbey, however. The presence of the Growler, the expansion, bringing in more Growlers, more operations, has had a profoundly negative impact upon the whole region. Many of you have seen news reports about how the Olympic National Park and the Olympic National Forest have been impacted by Growler training. They moved all of their electronic training from the deserts of Idaho, Mountain Home, Idaho, over to the Olympic National Forest, because it was more convenient for them. It's closer. But in doing that, they destroyed the tranquility in the Olympic National Forest. Same thing is true for EB's National Reserve. As Attorney General Ferguson mentioned, it's the very first National Historic Reserve. It was established by Congress to provide a piece of history for the Northwest that's essentially akin to Williamsburg in the East. It's our history. It was to show how the consistent agricultural life from the early founders, how it was, how it exists, and to preserve that tranquility in that agriculture. That has been destroyed by this Growler expansion. Our community is suffering. We filed a lawsuit, and we've been working with the Attorney General's office. We filed a lawsuit because the Navy just would not listen to us. When they were doing their DEIS, their draft EIS, and they were doing their community meetings, thousands of people showed up, thousands of comments were submitted, almost all of which were negative on the plan, to say this is not appropriate, this is insupportable, and this will devastate our communities. The Navy ignored all of that. They ignored it in their EIS, and they ignored it in their record of decision. We finally have somebody willing to stand up and speak up for us and say, no, you can't ignore that. So thank you again. As I said, our communities are hurting, but not just Central Whidbey, the whole region. I saw news reports out of the Methow Valley the other day about how the Growler training over there is disturbing their peace and their quality of life. You regularly see complaints from the Kitsap Peninsula, from Port Townsend, from the San Juan Islands, from as far away as Victoria, British Columbia. The Navy hasn't listened to anyone. Life in central Whidbey has become hellish. We literally are told noise is no big deal, but the military uses noise as a weapon. They regularly use extreme noise against our enemy combatants, and we feel essentially that that's the same thing that's happening to us in our homes. You cannot go outside while the Growlers are training. They're flying 200 feet above your head. We've measured the noise in the range of 105 to 120 decibels. Hearing protection only gives you about 30 decibels. It's still above the danger threshold. Inside our homes, we regularly measure sound from 90 to 110 decibels. We're told this is the new normal, you just have to get used to that. But what they're really telling us is that we don't deserve to have the same rights as everyone else, that we don't deserve the same human and civil rights, that we should just move if we don't like it. Well, we're not going to just move. We don't like it. We're going to stand up for our legal rights. There's been a long fight, but we're not going away. And now we have a huge ally, and I'm hoping that the rest of our representatives can take a hard look, as did the Attorney General's office, and determine that this just isn't right, that American citizens shouldn't be exposed or subjected to this. We'll be around to answer questions afterwards. Thank you.
Thank you very much. So just a final thought I'll just say is, as I travel the state, I've spent a lot of time, obviously, in the areas impacted by Growlers, Rotary Club meetings, you name it. I'm asked about this issue all the time when I'm over there. There's a big issue to that community, as folks in this room, I hope, our visitors here understand. So it's one I hear about a lot. And so we just really appreciate, and I know I speak for Bill and our legal team,